Hello and welcome everyone to this episode of Wicked, talking about published legal texts. And we welcome today Kyla Lee, who is, as you may know, one of the vice presidents of Women in Canadian Criminal Defense. Kyla is the vice president for BC. And today we've invited Kyla onto the show to talk about her book through LexisNexis called The Pinpoint Method of Cross-Examination. But before we get to talking about the book, which is the focus of this episode, for those under a rock who don't know who you are, Kyla, can you just give us a little bit of an introduction to yourself?
Okay. I am a criminal defense lawyer in Vancouver, and my practice focuses specifically on driving offenses, so impaired driving, prohibited driving, driving prohibitions, anything like that. If you do it wrong in a car, I care. If you don't, I'm find someone else. Yeah, that's me. I don't know. I've been practicing for 13 years now, which makes me feel old every time I say that.
You're an expert on drinking and driving and defending persons charged with those related offenses. You also, and we'll maybe do another episode on that, have a distillery. You make some beautiful gin and vodka as
Yes.
perhaps an aside. And I think you sing and you make albums and you're very you're present on social media in ways that you get a lot of engagement, which is wonderful. And I personally think that Kyla is the face of the profession going forward. So I'm very impressed with all the work you do. And in addition to all that, you've joined the ranks of published legal authors and women who publish legal texts in, was it 2021 or so when this book came out?
I think it was the beginning of 2022.
Okay. We wanted to hold up a copy of the book for you so we can show you what it looks like. And although Kyla and I both own copies, neither of us could find ours. But at some point, we'll link to where you can source beautiful little bright green, emerald green volume. So I want to talk with you about the pinpoint method in the book. And let's start with, is this your first book, first of all?
This is my first book, yes.
And what prompted you to write and publish a book in the first place?
Um, I mean, I always wanted to write a book. Even when I was like a little kid, I used to write books. They were not good. And I actually sent them, like as an 8-year-old, I sent books off to publishers and got the nicest rejection letters. Um, they loved my artwork. So it was always something that I wanted to do. And then I guess LexisNexis reached out to me and asked if I wanted to write a book, and I was like, absolutely, I do. So I came to them with my idea, and they were totally on board.
And was this your first idea? You wanted to write about the art and science of cross-examination?
I had 3 ideas. I wanted to write about cross-examination. I wanted to write about the BC Motor Vehicle Act, but they already had a text on that.
Oh,
Um,
scintillating. Yeah.
yeah, and impaired driving. And again, they already had a text on that. So this was like the fallback.
And so tell me about why cross-examination, why you felt that there was a need to look at cross-examination and this may be a second question, but what is it about the pinpoint method? Well, you'll tell us what the pinpoint method is. So why a book on cross-examination and what's the method?
I think cross-examination is a skill that we don't get taught in law school and in the profession unless you're doing it all the time and watching people who are really good at it do it. You really struggle to learn it. I mean, lots of the vast majority of criminal cases don't go to trial. So the vast majority of criminal lawyers are, mostly spending their time doing bail hearings and pleas. And when they do go to trial, I've watched people who don't necessarily have the cross-examination skills, which, is obviously disadvantageous to their clients. So I think it's important to have one. I also think it's important to have, there aren't a lot of cross-examination texts written by women. So that also is important, to have the perspective of a woman doing cross-examination. It's different than for men. And I also, I'm friends with Matt Dodd, who's Roger Dodd's son, and he works with them on the cross-examination workshops they do. And I always thought like the method that, Posner and Dodd, the um, McCarthy method, they were all very similar and kind of boring. So I wanted a more exciting way.
That's okay. You don't have to whisper. No one's going to listen to this episode. No. Um, so I'm interested in your comment about why it's different for women, why cross-examination is different for women than men. Well, I have my own theories, and I agree with you, the Posner, Don, all these other sort of older white men talking about cross-examination. It's quite rigid. The system is rigid and um, it's prescriptive. Like you've got to do this or you will fail. And I don't know that that's necessarily the case. So why do you say it's a different thing for women altogether?
Think there's two sides to it. The first side is obviously as women were perceived differently by witnesses often. Women are generally perceived as being, softer or weaker because of awful, horrible stereotypes about women. But also when women, exercise their power, they're perceived as being bossy or rude. And so, when you have that kind of perception as you're cross-examining, that can create this tension with the witness when you want to build a relationship with the witness. So there's that. There's the perception of women, and how that influences us. But also, I think, as women, because of our experiences that we've had with misogyny, we often tend to lead more with relational things, with our sort of more vulnerable emotions and building connection. And because, as you said, like the other methods are very rigid, they're not necessarily about forming this bond with the witness and getting them to give you the answers you want. I think it's nice to have an approach that is specific to the way that we as women work.
Would you say, in my own experience, I and never necessarily reflected it on it as a gender-based thing, but I think if the if the sort of traditional approach to successful cross-examination is you reel them in at first with the positive stuff you're trying to get from them, nice, make a friend of the witness, get them on side, and then, switch around when you want to go for the jugular. In a way, sometimes perhaps it is easier for us as women to get that initial phase going kind of quickly because, for whatever reason, stereotyped or not, the witness is expecting us to be nice, expecting us to be agreeable, nurturing, and helpful. And then they're very surprised when we turn on them, right?
Yes, the look of betrayal is it's kind of one of my favorite parts. It's not very nice to say. I do love it. I love the look of betrayal.
Well, that's the thing about criminal defense lawyers and lawyers who are litigators, right? Is we live for that moment. We live for that j'accuse, and we got him. So what is the pinpoint method, first of all? And then how is it different?
So it's a method of thinking about the whole case and then sort of tying every piece of your case together. So when I use the analogy of essentially sewing a quilt in the book. So the pinpoint method is thinking about all the steps that you would have in sewing a quilt are basically the same steps that you would have in doing a successful cross-examination. From, first of all, making sure you're never losing sight of the big picture of the case because you need to put your theory to the witnesses, but also, narrowing down everything to, to the very fine point. Because oftentimes, and especially in my practice area, a very fine detail can make all the difference in a case. So, having the skills to sort of work from here and narrow it down to the pinpoint of the case can be helpful. So that was kind of why I did that method.
And how would you, I mean, people can look at the table of contents, they look up the book online, but how did you go about structuring the book?
Uh,
What are the chapters like? Do they flow in terms of how a cross would unfold or what you need to think about, or how is it organized?
So the beginning of the book deals with sort of the overarching goals of cross-examination, why we cross-examine, and then ethics, but then it gets into structuring your cross-examination and everything from how you're going to deal with your materials. You've got hundreds of pages of disclosure. How are you going to organize them? How are you going to review the materials to prepare yourself to write the cross-examination? What you need to do, I give some examples of ways to organize like charts about witness evidence, so that you can go back directly to points in the disclosure that will allow a person to identify what's good, what's bad, what you want to confirm, what you want to refute, what raises, a contradiction between other witnesses. And then, incorporating that into how to structure your questions. And obviously, like just like the Posner and Dodd and McCarthy methods, still always wanting to start with the yeses, and the answers that are positive to your case and that the witness is going to agree to. But it also breaks down different types of witnesses, the common types of witnesses that you would encounter. Obviously, like expert witnesses, police witnesses, but then I like to give the witnesses little nicknames in the book, like the pontificator, people who you ask them a simple question like whether the sky was blue, and they give this big long answer about the reflection off the ocean.
Oh,
You
I call those the psychiatric witnesses. Yeah.
know,
The psychiatrist is expert.
yeah.
They've like 20-minute answers about everything that they've ever thought about that might be interesting. And then the question was like, did he take his medication that day?
Yep, those people are.
So the pontificator, what are some other
Um, the
names?
the if you say so witness, which you
Ah,
often
yeah.
see with police officers or civilians who like to cast themselves in an adversarial position to your client. You put something to them that they will easily understand is detrimental to the Crown case. And well, if you say so, and how to handle that, how to handle that witness that's not agreeing, but they're making it look like they agree. Because a lot of people miss that if you say so is not agreement, it's not getting the answer you want.
So
And
how do you handle if you say so? What's a quick and effective way of handling if you say so?
I mean, my go-to the first time I hear it is, well, I am saying so. So you're agreeing? And then,
That works.
yeah,
That works. So in your practice, the kind of defense work you do, the witnesses that you cross-examine on the daily include police officers and I gather experts.
experts and civilians who watch accidents happen.
Yeah. That's an interesting class of people. You hope not to see the same person again and again as a witness. And so does the book cover, because one of the things you and I talked about when we were thinking about talking about your book, uh, is you can anticipate to a great degree, often, what kind of witness a witness will be in terms of whether they're going to be helpful to you, hostile towards you. You have some sense usually of what their evidence will be. You'll have had a will say or some idea. But every once in a while, the witness presents very differently, the polar opposite of what you'd expected. So witness you wanted to take down, you thought would be easy to take down, ends up being a bit of a teddy bear, a bit of a sweetheart. And particularly in front of a jury, if you deliver the cross-examination you plan on that very sweet, helpful person, they're not going to like that. Or the other way, someone you thought would be easy enough, a factual witness who'd be agreeable, turns out to be some kind of nightmare. So how do you switch gears in that type of situation? I ask you because, in my experience, that's the kind of hurdle that's very difficult for a new lawyer who has scripted each cross-examination question that they wanted to follow quite to the letter. It's very hard to switch gears. Is there any advice in the book about that kind of thing?
There is, and a lot of it comes down to understanding those, classic witness types that you get, so that you've already built the strategies or you know what the strategies are, and then you can, switch on the fly. But also the things that the book suggests you prepare in advance. So the charts that you're going to make, the documents that you're going to have to present to the witness, even if you have to deviate from your script. And I don't marry yourself to your script. That's like the worst thing you can do. I script every cross-examination, and then by like the 10th question, my script is just reminding me of what I'm supposed to ask about. But you can deviate from what you've planned to ask because you know you have in your arsenal, in your little binder for your trial, what you need to impeach the witness, regardless of what type of witness they are, or what you need to point the witness to the things that are helpful to your case, regardless of what type of witness they are. You will have something that can guide you to bring you back exactly to what you want to get out.
Well, let's talk about preparation. So you're, either in or headed into your 14th year of practice, and you've just told us that you still script and draft every cross-examination. So what would you say to the new lawyers or the very old lawyers, because you get this on both sides, who don't bother to draft or plan that cross-examination because they think they either have the experience or, will somehow, due to their intellect and abilities and God-given natural talent, can wing a cross-examination without preparation. Maybe they've read the materials, but they don't want to go to the trouble of actually writing out a cross-examination. What advice or comments to that would you have?
I mean, I think that's terrible not to actually go to the trouble of sitting down and writing it because that exercise forces you into, the realm of imagining how the witness is going to respond, what they're going to say, and anticipating, where they might deviate, whether they're a dishonest witness and they're going to deliberately deviate, or where they might deviate because something's a little ambiguous or unclear or not stated. You're forced into the position of being able to anticipate all of the ways the witness is going to wiggle away and prepare for it. So then when it does happen, which inevitably it will, you are not, shuffling through your papers and losing your sort of position of power. The last thing you want to be doing is like stopping in the middle of your cross-examination and going, Your Honor, may I just have a second, and like flipping through your material to try and find something that you should have known where it was.
Um, so you said, and this is always the case, that, 10 questions into it or 10 minutes into it or even earlier, the script goes out the window. Things have gone, a different way, inevitably than what you had planned in the order that you planned. So what's the value, despite that, of having written things out and thought about the questions and anticipated the different kinds of answers? If you have to inevitably put your notes aside at some point, what's the value in going to all that trouble to map out a proposed cross?
I mean, for me, the biggest value is it makes me become so much more familiar with the case. I can read the file 100 times, but until I'm actually sitting down and writing all of that, there are details that my brain is just not focusing on as being important. And when I, put myself in the imaginary courtroom and write out the imaginary cross with the imaginary answers, all of a sudden I'm seeing more things that I didn't see before in the file or in the way that the evidence is structured. And that I think gives me just the confidence that I know the case like the back of my hand, and I'm going to be able to ask every witness whatever I need to ask them, even if I go off the script. But the script is also great because it also helps you with the confidence of if things start to go bad, I know I can go back to this. I know that I've prepared for these things and I can go back to something else. I can regain control of the witness and then I can go back to, being off script and just dealing with the issues that I've identified.
So when you sit down, this happens to me, and when you sit down to write a cross-examination, do you find that you start with a big question because you're thinking about asking, what happened, but if you're forced to write out a cross-examination, that one question is going to soon come in, become 20 or 30 or 50 questions as you break down each element of what you're trying to take the witness through. And does that then in turn make for a much more effective cross-examination the shorter your questions are, if you're able to bring it down to one fact per question? And does writing it out facilitate that?
Absolutely. I think one of the things that happens to all of us when we're cross-examining is we get a little excited and we, a lot of young lawyers make the mistake of jumping to the conclusion first and telling the witness where you want them to go. And doing the physical act of sitting there and breaking down each question on each issue is, it's training your brain to think about it that way, so that if something does come up that you didn't anticipate, or something new, comes out, which inevitably it always does, you know how to break it down. You're not going to go jump to, well, you wrote a police report, and in your police report, you didn't indicate that the person had slurred speech. And now you're saying today that it had slurred speech. And you could hear, you like, there are lawyers who will ask the question that way. That's not the way
Yes.
to do it.
And it's fun to see a question like that. I do a lot of appeals work, so it's fun to see, this 20-line question like that, and then the answer from the witness is either yes or no, which is profoundly unhelpful because there have been, 15 different areas canvassed in that question. You don't know what they're saying yes to or no to. So I just want to, I won't keep you long. I know how busy you are. Just a couple of other questions for you. Um, all litigators, my own views, will develop their own style despite these rigid rules. You know, uh, when I was first called to the bar, when I was a law student, learning how to do appeals, for example, all I remember is I was told to grip the podium with two hands a certain way and stand very still, gripping the podium for fear that I might otherwise use my hands. And I remember initially trying to do that, which mind you just, made me look terrified. Like if I'm hanging on for dear life because if I don't, I'm gonna pass out or something. And, relatively quickly I learned that I'm someone who uses her hands, and that's not the cardinal sin that I was taught that it would be, and that if you do it in a way that's not unduly distracting and can actually be helpful in punctuating some points. And regardless, it is who I am. It's what makes me comfortable on my feet. Do you have any advice in the book about developing a personal style, or for women, not being afraid to use your own voice, being authentic, despite, some of these rigid rules that we may hear from some of the men?
Absolutely. The book, emphasizes, I think, repeatedly the importance of developing your own way of doing things, because everyone's going to find something different. Like, I have a section in the book where I talk about how your cross-examination begins in the hallway. Because for me, one of my favorite things to do is I go up to the witness in the hallway where they're waiting for court to start, and I start chatting them up and getting to know them. I sat once in waiting for, there was a plea that was happening before our trial started, so waiting for 20 minutes watching funny animal videos with the officer I was going to cross-examine shortly after. But it gave me this opportunity to get to know them on a personal level, which for me made them more malleable as a witness, because then we already have this pre-existing bond and relationship, but I also knew more about them and who they are as a person that I could then incorporate into the way that I phrased or structured my questions, so that I could get the answer I wanted. So, for me, that's something I would do. I think maybe other people would not
Did
watch.
that officer ever sit down to watch cartoons with you again another time, or
I haven't
maybe?
ever seen him since, but I'm
No,
sure
yeah.
he would.
Some of these things only really work once,
Yeah.
but I applaud you for trying. That's another thing. I mean, maybe that's a whole other book, but I do find new lawyers often may or may not even realize that they're entitled to speak to witnesses that the Crown is calling, or other parties may be calling in different types of litigation. And I agree with you that preparation can include speaking to that witness. There's nothing wrong with that. There's no property in a witness. And I think sometimes that lawyers are afraid to engage in that way. As long as you do it ethically, it can be a big leg up. Um, so when I read the book, I loved it. I thought it was bringing new eyes and a fresh perspective and a different approach, a modern approach to cross-examination. And I think it's super helpful for young lawyers for whom I think cross-examination is daunting. My own view is cross-examination is at the heart of any trial or litigation process. I mean, other parts are important. Your opening statement, your closing statements are important. Examinations in chief, can be insufferable if they're done poorly. It's nice when they're done cleanly and efficiently. But where things make it or break it, my view is cross-examination. And it's also the most fun, as you say, right? It's the skill that I think If you want to be a skilled trial lawyer, I think you need to be skilled at cross-examination. And I don't know of too many resources out there like the Pinpoint Method. So certainly the feedback I've had when I talk to people about the book is that it's really helpful to them. Have you had feedback from new lawyers or other lawyers who find it useful and improves their cross-examination?
I was actually shocked when the book came out. But at the number of people who bought it. I was like, wow. And then B, the number of people who contacted me and said, this has totally changed my approach, or this has been so helpful. I was doing my first cross-examination, and now I know what to do and how to do it. And I always find that like very flattering.
And it's not a word of a lie because I read it, shortly after it came out, but that's only, 3 years ago. And by then I'd been practicing 30 years and it was useful to me as well. So I don't think it's just new lawyers or people starting out. I think for people who've been around a long time, even if you are good at cross-examining, there are always tips and tricks that you can try. And one of the fun parts of being a litigator is you can try new stuff. Some things you try are gonna fail. Like we do learn by trial or an error, and some things that other people can get away with or do successfully don't come out well out of my mouth when I try and do it. But you have to sort of learn that as well. So I think there's a lot in the book that senior counsel would actually enjoy reading if you're someone who enjoys cross-examining, but particularly for new lawyers, it's a tool, I think, in your toolbox. Nothing replaces, let me know if you agree, actually doing it yourself. Like you must get as much practice. It's hard to get trial experience, to get the files and the clients. But once you do, any opportunity, whether it's to cross-examine one witness on one issue, any opportunity to cross-examine, any opportunity to moot, to do trial advocacy, to do mock trials, I think is all helpful. And the one other thing that's really helped actually improve my own cross-examinations, your book and teaching trial advocacy. So teaching other people how to cross-examine. And I think for you writing the book, so talking about it, writing about it, teaching, showing people how asking a question can change helps us to see how things can get better. So no doubt, I've seen you talk about cross-examination. You've done some CPDs for us on cross-examining on certain kinds of issues. I would not like to be in the witness box to be cross-examined by you. I'm very happy to go to my grave without ever having been cross-examined by you. And I think
Probably likely.
there's a good chance I'll never have to be cross-examined by you, but I think it's a great tool. I hope people will buy it. More people will buy it. I'm glad lots of people will buy it. We will put the link to the LexisNexis page where you can buy Kyla's book. It's well worth every penny. It's very reasonably priced. There may even be some electronic access or student access. We'll see when you go to the web page. And I encourage you to include it in your law library at your firm, for your younger associates, for yourself, if you're interested in perfecting the art and science of cross-examination. Is there anything else, Kyla, that I haven't asked you? We could ask ChatGPT if I missed anything. Is
Uh,
there anything you want to say about the book that you want people to know? Is
it was,
green
it
your
was
favorite color?
Sorry, it's
Is green
green is my favorite color, actually, yes.
beautiful emerald green? Sorry, what do you want people to know about the book?
Was gonna say it wasn't written by ChatGPT because it didn't exist at the time, but if it did when I was writing the book, I would have included a chapter on why you don't use ChatGPT to write your cross for you.
That's true. Well, that'll be volume two, a sequel to your book that I would like to see. I think you should continue. I think it should be a full series on various parts of trial practice. And I'd love to see, you could do, next time you could do a chartreuse or a teal, have a whole array of green covers. I'm very focused on the color of book covers. I am thrilled that you joined the Women Publishing Legal Textbooks with the Pinpoint Method. Thank you for your time today, Kyla, and thank you for all the work that you do for Wicked as our West Coast Vice President. And no doubt we'll see you again. Um, So thanks for this.
Thank you.